Hello out there, all you cool cats and kittens. I am attaching how the children move through the welfare system and presenting this PowerPoint to you again because it has been revised. And some of those revisions include questions about court and answers, and also the new timeline for DCS, and how to better understand when you have a CHINS case and a termination or JT case. So hopefully this PowerPoint being revised will help you understand it a little bit better. And I'm doing audio on this. Now, whether or not that helps you out or not, I don't know, but I sure hope it does. So let's get started. So we have the 800 number. We're always going to put that out there because anybody that you know that comes to you or suspects child abuse and neglect, you need to pass that number on to them because they're the best ones to report it because they're the ones that have the firsthand information, not you. So everyone in Indiana is a mandated reporter, so that's what we always need to remember. When people come to you and talk to you about child abuse and neglect, and I get that a lot, people telling me I don't know why they get away with it, nobody's doing anything about it, but a lot of times they aren't doing anything about it, and one of the first things that you need to do is to report this suspected child abuse and neglect. And a lot of times people think, well, I'm not a police officer, I'm not a teacher, I can't report this. Yes, you can. Those people are legally obligated, but you're mandated to report. So it's really important to pass that on to them and let them know, hey, everybody's supposed to report child abuse in Indiana. So do the allegations meet investigative standards? So the hotline will evaluate the call as to whether or not there's a reason to believe there's a safety concern, and they'll inform the caller if the hotline intends to recommend that your county screen out the call or screen in the call. And then once the local level gets it, they'll determine a response time based on the severity of the allegations. So that could be immediate, 1 hour, 24 hours, or 5 days. Local DCS, of course, will send out an assessment caseworker to investigate, and when the assessment worker goes out, they try to determine whether or not it's an imminent concern, some type of safety concern, or if they just feel like there aren't any concerns at all, and they'll either advise the family, you know, hey, we're going to close this out now, or we're going to enter into an informal adjustment, and we usually call that an IA. The family does that voluntarily, and they can work with DCS to get some services provided to their families, and these can be open for 6 months. They can also request an extension for up to 3 more months, or DCS could say, hey, these families aren't doing anything that we've asked them to do during this informal adjustment, so we're going to get the court's involvement on this. So if the assessment worker determines that the child's at imminent risk or safety is an ongoing concern, and that it won't be eliminated or addressed without the intervention of the court, DCS will petition the court for a request to take custody, along with a petition containing the allegations and reasons why they're asking to take custody. And that could be an out-of-home CHINS, or in some situations, DCS will also file for an in-home CHINS. Once DCS makes that decision to request the court's intervention, they have to file that request for a hearing within 48 hours for a detention hearing. So usually parents' initial hearing is held at the same time, but not always, because sometimes parents aren't there for a detention hearing, and that's okay. DCS can go ahead and have that detention hearing on that date. An in-home CHINS does not have to be filed in that time frame, but will need to be filed in order to have an initial hearing for the parents. At that detention hearing, the court is going to determine if there was cause to detain. Now, sometimes the court will find that DCS doesn't have enough information or reason to detain, and they'll deny that petition. They'll ask the parents their opinion on where they think this child should be placed, because sometimes parents don't want the children in foster care. They might want them with relatives. And then the court will ask DCS about placement. Where are the children? Did DCS try to locate family? And if they're not with family, why are they not with family? And judge makes a determination on placement for now. And then the CASA program is then assigned at that first hearing. At the initial hearing, the judge explains to parents why they're here. He requests DCS to explain those requests, and then DCS will read their verified petition and the allegations as to why we're all here today, and the judge will ask parents if they heard and understand that. Judge reads parents their rights in a CHINS matter, and he asks the parents if they understood everything. He also asks parents if they'd like to have counsel appointed. Most parents do accept a court-appointed counsel. Some parents waive their right to that because They say that they'll be getting their own counsel, and then the judge asks them if they admit or deny the allegations. So if they've requested counsel, the judge will always enter a denial on their behalf because, of course, if they have an attorney, they need to speak to their attorney before they enter anything. If parents request counsel or deny the allegations, DCS and the court will set out hearings, a pretrial and a fact-finding. They only do that when a denial is entered or if the parents still need to speak to their attorneys. If parents admit, they don't do that. If parents admit to the allegations, DCS and the court will set out a hearing for a dispositional. And DCS will file a report that outlines everything that they're requesting the parents to do in order to be reunified with their children, and the judge will issue an order on that. And that will be the dispositional order. So what are parents admitting to? So if parents admit, this means they're admitting that their child is indeed a child in need of services, what we call CHINs. Some parents are confused and believe they're admitting to something criminal, but that's not what is happening. This is not a criminal case. CHINs cases are civil matters, and the burden of proof is on DCS. So it's not as high as a criminal matter, but it's more than likely to have occurred. Pretrials. Pretrials are mainly set at a time for attorneys to inform the judge if they have been provided a witness list and discovery, and to let the judge know if they're all ready to move forward or if any of the parties feel they need more time. Sometimes they'll ask for a continuance. Normally they last about 5 minutes or less. So remember, the case will only be set for a pretrial if parents deny the allegations. So what is a fact finding? This hearing is a civil trial held before a judge, not a jury. So DCS will try to prove that the allegations that they put in their petition of neglect or abuse are more likely than not to have happened. This is held within 60 days after the filing of the CHIN's petition, and we only go to pretrial and fact-finding if parents deny the allegations. If parents were to admit, we'd go right to a dispo. The court may grant an extension for up to 60 days if all parties consent, strictly capping this phase at 120 days. I do know with the new guidelines, they're trying to cut back on all these extensions or continuances. If DCS does not meet their burden, it will be closed. The whole entire case will be closed. If DCS does meet their burden, the judge finds that the child is indeed a CHINS, a child in need of services, and then we'll go to a dispositional hearing, and that will be set. What is a dispositional hearing? So if parents admit or the judge has adjudicated, which means he did find this child a CHINS through a fact-finding hearing, the next step is for DCS to outline, hey, what services do we want these parents to do, and do we want this court to order these parents to do to reunify with their children? And that's 30 days after the fact-finding or the first hearing. At this hearing, the court decides what orders should be made regarding the child's placement and what services are needed to help get the child and their parents back together, which is reunification. The goal is to get them all back together if possible, and that's what these services are supposed to be geared towards doing, reuniting these families. More hearings. So we have review hearings. After the dispo hearing, a review will be set. Reviews can be set 3 to 6 months out. CASA volunteers always have to have a report at these hearings. A CHIN's case may be reviewed every 6 months. Parents' progress or lack thereof will be discussed. Services are being addressed, followed up on, compliance, what is being offered, any issues or concerns. And then, we always talk about what permanency looks like, whether it's the permanency hearing or not. So whether that child should remain where they are currently and why, or if they need to move, or if they need any other services. After the next review hearing, DCS will normally set a permanency hearing. Permanency hearings are held every 12 months after a child has been removed from the parent, every 12 to 18 months after the first hearing, and every 6 months thereafter. A lot like a review, but focusing on whether or not the need for intervention has been eliminated. And if that's the case, then we might be looking at a trial home visit, or we might be looking at reunification and just closing the case. So we're focusing on what permanency looks like for the family, whether DCS should maintain the jurisdiction, and determine best permanency options for this child. And then this is the slide that talks about CASA and hearings. So CASA volunteers do not need to attend pretrials, but you can. If you want to, you can. If you feel like you want to know more about your case and you want to be at every hearing, I don't mind that. I just don't want you guys coming to hearings if you don't need to be there and you have something else you need to be doing, like work or a school or something. CASA volunteers do not need to attend a fact finding on the detention. These fact findings are based on why this case is being open and why DCS detained in the first place, and we weren't involved in that. So you don't need to be that because you're not going to testify at that. But like I said, as far as pretrials go, you can. If you want to be there and you want to learn more about your case and you want to hear testimony, by all means be there because you're a party to the case and you have a right to be there if you want to. A CASA volunteer will provide report and attendance is required for dispositional most times, but review hearings and permanency hearings always. And then as a CASA, you're going to sit at the CASA table, you're going to give your oral summary when called on. CASA is the voice for the children in the courtroom, so you're able to give details about the case that may never be heard unless the CASA is actually on the case. And of course, I'll always sit with you during the hearings. CASAs are on the child's behalf and what is in the child's best interest during all hearings. CASA reminds everyone that there is a child in this case because sometimes at hearings I hear very little about children, and that's why it's so important for you to be there if you do have a hearing, or if you're not going to be at the hearing, please let me know and fill me in on your case. One of the new sections I was talking about with questions and answers. So if you have a question about whether or not you need to be at a hearing, ask Sherry. If you have a question about whether or not you need a report for a hearing, ask Sherry. If you have a question about a hearing being continued, please ask Sherry. If you have a question about a purpose of a hearing, just ask Sherry. If you have a question about the outcome of a hearing, go ahead and ask Sherry. So if you're receiving information about what happened at a hearing from parents, placement, or DCS, please get with me to confirm that. I know so many of you have had this happen. I've had it happen myself. Parents, grandparents, placements, even DCS will be at court and they have no idea what happened and they'll come to you and tell you something that happened at court and you're like, what? Just ask me, because even if I'm not sure, I'll ask somebody and I'll find out for you. DCS is separate from CASA. We are officers of the court. CASA has different policies and procedures, and that goes for court as well. So DCS doesn't know if you need to be in attendance at a hearing. DCS does not know if you need a report for your hearing. So just remember to ask me, and just refer all things related to court to your supervisor, which is me. So many times you may have a brand new FCM and they really don't have a true understanding of the hearing themselves. Same is true for placements. They may believe or truly want something to happen in a hearing but don't really understand or interpret the proceedings correctly. So just ask me. I've actually been attending these hearings for a long time, and even I get stumped sometimes because there's a lot of ramblings, there's a lot of court talk, but I will always check with the courts if I need to, just to be sure you get the best information possible. If I mess up, please call me out on that and I will fix that mistake, I promise. But just please, please, please ask me. And this is the slide I was referring to when I was talking about the timelines. So the reunification services are going to look a little bit different because after June 30th, 2026, the limit is 12 months. Now that's not a lot of time, folks. Now I did put in there about extensions. The court can grant them, but the thing is with the extensions, DCS has to file for a hearing for that. And then they have to bring their evidence as to why they want an extension, and then the judge has to approve it. So it's kind of a process. And so now that we have this 12-month reunification cutoff, so they have to, after 12 months, start looking at TPR. Now, I think some foster homes may be like really happy about that, but if you're thinking about parents that are struggling with substance abuse and they're really wanting to get their children back, 12 months isn't a long time to be able to get sober and do all the services needed to get your children back. So these parents need to start from day one. And then it talked about strict fact-finding deadlines. The court must commence the actual TPR hearing within 90 days of filing and completely conclude it within 180 days. So there's another cutback there. They're wanting to cut back on these continuances and these extensions on this fact-finding for TPR. So they're not going to have a lot of wiggle room there. And like I said below, it's obviously new to all of us. We're going to have to wait and see how a lot of these things play out. It would be interesting to see because I know now the new guidelines say that foster parents can intervene and say that they want to file and get the TPR started. I haven't seen that happen yet, but that's something new. So just like with everything else, the things are always changing within the system. And we know that because the policy is changing all the time. So we're all just going to have to sit back and see what happens with this new 12-month reunification cutoff. I think it'll be very interesting and see how it plays out. And then this is when I'm going to talk about concurrent cases, but I'm not talking about concurrent cases for your families as far as permanency. I'm talking about concurrent cases for you guys as a CASA. So understand the differences when you have a CHINS JC case and a CHINS juvenile termination case, which is a JT case. So I thought about, why don't we compare this to doors? Maybe that might help you guys see it from that perspective. This is a visual cue for you. And you have this open CHINS case. So we see this door with the CHINS JC on it, and this door identifies your child and your case. So this is the door that you submit reports for and you attend court for, and you give a summary and review at review hearings and permanency hearings, and this will remain open for the life of your case. When your child is reunified, adopted, or in a guardianship that has officially been granted, DCS will file to close this door, and then that door will be shut, and then you'll be done with that case. But when DCS files to terminate parental rights, this opens a brand new door. So you'll see over here on the right, you have the CHINS JC, and over on the left, you have the CHINS termination JT. So now you have two doors, the termination door and then the CHINS door. The only hearings CASA has to officially attend on their JT door is the fact finding. So I'll let you know that date. And if I haven't, then get with me and find out. At this hearing, you give testimony. You don't present a report or anything like that. You give testimony. You're going to hear testimony from DCS, parents and parents counsel. They provide witnesses as well. CASA testifies. You do not need a report for this hearing. So this hearing can last a half hour to 4 hours, and sometimes it can be continued for a second day. I want to tell you that rarely happens, but sometimes it does. Sometimes parents come to the hearing and decide they want to sign a consent to adopt, and then there's no need for a TPR hearing. So that's why I put a half hour on there, because sometimes these hearings don't even happen. But right now you still have two open doors. One's for termination and one's for the JC CHINS. But remember, at termination hearings, the only one you ever have to be at is the fact finding. And then it talks about the termination case door closed. So once the judge has entered an order on his decision on a termination or a JT case, that door is closed. So you don't have to worry about it. After those 3 hearings, you don't have to worry about it again. Even if the parents appeal, because they appeal at the state level, not the local level. So during that appeal case, they'll have totally different counsel, and CASA is not appointed to the appeal. So you no longer have anything to do with this door. Just shut it and leave it closed. The CHINS door remains open. So this CHINS door is always going to stay open for the life of your child's case. So DCS generally will file to close a case if it's decided the family can work through its issues with an informal adjustment. They'll close a CHINS case for that. Or if it transfers to another county, they'll close that door for that. Or if this child is reunified with their parents, adopted, or a guardianship has been granted, they will shut that door for that, and you don't have to worry about that case anymore. Or you could have a situation where the child ages out and they no longer wish to participate in any programs with DCS, and they will shut that door for that. So once the court enters the order to close this CHINS case, the CASA role is terminated as well, and you no longer have to worry about that door. So like I said, once the court enters the order to close the case, the CASA role is terminated as well, but once your CASA door is closed, you're ready to be assigned to a new door. Isn't that wonderful? So just get with me and I'll have a new door ready for you. Final thoughts. Listen, there are so many elements: players, issues, services, hearings, emails, thoughts, meetings, reporters, conversations, policies, DCS, providers, CASAs, protocols, terms, legalities, timelines. Listen, I get it. It's a lot. And all we want to do is handle our cases and do what's best for our kids. I so get it. I just remember I've been here a minute. I've seen and heard a lot. I actually also know a lot about CASA advocacy, and through that I've learned about courts, providers, children's, family, probation, criminal matters, all of that. And guess what? I still mess up and make mistakes. But I really want all of you to feel comfortable coming to me about anything in your cases. If I don't know, I will find out, folks. And I know we always talk about how in court DCS has their own back. Attorneys have the parents' backs. And you guys are there for the best interest of the child. But do you guys ever wonder who's there for you? Well, listen, my friends, the answer to that is me. So I'm always going to try to give you the best direction and information that I can. I want to support you guys. I want to ensure that your cases will end with the best possible outcomes. I know it's frustrating because best possible doesn't necessarily translate to ideal outcomes. And I know a couple of you have had some really stressful times on your cases here lately, and my heart really goes out to you. I know that's really hard to deal with. And not every case, obviously, as we talked about before, is roses and rainbows, but I'm really here for you guys. I want to support you guys through that. It's very important to keep me current on your cases. Even if I haven't reached out, please send me a monthly or even bi-monthly update if your case is moving as you think it should. And by all means, send weekly updates if your case is in crisis or not moving in the direction that you feel is best for the child. And please, guys, see your child every month and know when your court dates are and communicate with me. Transparency and communication is key to the success of your cases. And let me tell you something, you guys are doing things great, and I appreciate you so much. We both do. We think you're superheroes. And I just want you guys to feel supported because I don't want to lose any of you. I think you're amazing, and I want you to stay on as CASA volunteers. So I hope that this PowerPoint has helped a little bit, and I will add that once you guys reach out to me and let me know that you reviewed it. I will add that to your training hours. Okay? So you guys have a great week. Thank you so much for all that you do.